Hello, I'm Andrew Flushy. I'm talking to you today about reckless driving on vehicles other than cars. You may not have realized it, but you could be charged with reckless driving, even driving something like a moped or a scooter. You don't need a driver's license to drive a vehicle like that, but the law defines a vehicle as anything basically that transports a person, except for something that is powered solely by human power. So using that definition, we can see that anything that a person can be transported on or ride in is a vehicle, except something that relies solely on the human to power it. So that would mean that a bicycle or tricycle or anything like that would not be a vehicle. However, anything that has any kind of motor, whether it's a little electric engine or a little two-cylinder engine, anything like that, would be considered a vehicle. So a moped or a scooter or even an electric bicycle would be considered a vehicle under the code. And then reckless driving, the statutes refer to vehicles. The general rule 46.2-852 says that you can't drive any vehicle in any way that endangers the life, limb, or property of somebody else. The statutes clearly are meant to work together, and they clearly encompass vehicles other than cars or trucks like we normally would think of. And so that's just something to be very careful about if you're driving any kind of Vespa or scooter or anything like that, anything with any kind of motor where it's not just you pedaling doing the propulsion. You need to be very careful about your operation because you could be charged with reckless driving. And it's very serious, and it happens, much to some people's surprise. So just remember that the law is pretty broad, and a vehicle could mean a lot more than what you would normally think of as far as the way the law defines things. So reckless driving could entail cars, trucks, scooters, mopeds, electric bicycles, but not a regular bicycle that is solely powered by human pedaling.